An anonymous reader has sent me a question this week that I can break down into two legal issues. The first is whether it's a criminal offence to open up someone else's post. And the second is, in the same scenario, if you do open up someone else's post and you find inside the letter that there's a letter from an enforcement agent, can you contact that enforcement agent and stop them coming to your property? Do you have any rights? Now, I'll start this journey today with a bit of law which is called the Postal Services Act 2000. That law says that on the face of it, it is a criminal offence, it is illegal to open up someone else's post. But there is an exception. The exception is you may do so if you have a reasonable excuse. Now, if I bring this back to the anonymous reader's question today, they tell me that inside the envelope was a letter from an enforcement agent, and it appears that it was obvious from outside of the envelope, whether it was because there was a mark on there, a stamp mark that had their logo, or whether the anonymous reader could see through the clear window the letterhead. It was obvious to them that this letter was from an enforcement agent, and it follows that the anonymous reader would have been concerned as to whether that enforcement agent was going to show up at their property and perhaps try to take away goods that were theirs, not the debtors who owed the enforcement agent money. In those circumstances, my view is that that did give rise to a reasonable excuse to open the letter, therefore meaning that it was not a criminal offence for this anonymous reader to do so. I now move on to the second issue. What can they do about the enforcement agent? Well, again, the law says that the enforcement agent on this occasion cannot take away goods from anyone apart from the debtor, the person that owes money, or the person that owes the money that they are chasing. Now here, that's not my anonymous reader. So what has to happen next for the anonymous reader or anyone else who has the same or similar situation is they've got to go back to this enforcement agent, look at the letterhead, find the contact details, tell them that the debtor in question does not live at the address where the letter's been sent. They'll have to follow that up with some proof. So the proof will be proof of identification of, in this case, the anonymous reader, driving license, passport, anything with a photograph and address attached, and proof that, in again this case, the anonymous reader is either the tenant of this property now, you'll do that by showing a tenancy agreement, or owns the property, perhaps show your deeds with the property or a letter from the solicitor that you used to buy the property, anything that proves the point, and perhaps a utility bill, which shows that the utilities for this address are in the name, again in this case, of the anonymous reader.